Okay, so the IT gods have given us the green signals. So without wasting any time, let me offer endearments to all those present over here. My name is Ankit Malhotra, and I am the president and co-founder of the Jindal Society of International Law. Amongst us today, we have a very distinguished scholar and professor of international law from NYU. Before I introduce our speaker, I would like to speak a few words about the Center for UN Studies. The Center for UN Studies aims to develop a learning platform on opportunities and limits of the United Nations by enhancing research and building a knowledge on how the United Nations systems work, both in terms of institutional development, in terms of promotion and implementation of various multilateral policies. The center is spearheaded by Professor Dr. Weston Popowski, who has, in his discussions with me, often shared a tale which I would also like to share over here. He's often told me that in 1953, the first UN Secretary General, Trygve Lie, welcomed his successor, Dag Hammarskjöld, arriving in New York saying, "Welcome, Dag, to the most impossible job on this earth." The UN, which is often criticized as a scapegoat, has failed to live up to its initial expectations of its founders. But let's also be reminded of what Hammarskjöld famously said as perhaps a response. He said, and I quote, "The UN was not created to take us to heaven, but save us from hell," end quote. The Center for UN Studies engages in projects studying the history and the traditions, but also takes a transformative approach to research, teaching, and social engagement, having in mind the latest and most cutting-edge dynamic geopolitical technological shifts. The center and its sister is the Jindal Society of International Law, which was created, as we were discussing, in the midst of the pandemic in 2020, and is a quorum of thought-provoking discussions, which is a student-led initiative, yet supported very strongly and appealingly by its professor members. We also have one amongst us today who will be acting as a commentator. We welcome and appreciate Professor Akriti Tripathi, who has very kindly accepted our invitation to act as commentator. Let me also share what the Jindal Society of International Law and Center for UN Studies lecture series of which this lecture is about. This lecture series, which is the lecture series entitled Exploring the Ecosystem of International Law, is building upon the introduction to internationalism and international law by the concluded summer lecture series titled Future of Internationalism and International Law. The fall lecture series endeavors to study the different contours of international law. To assist in the study, the speakers will cover and address the respective areas of expertise based upon their years of research and practice. Given the vast ecosystem and the engagement of international law in it, the Society aims to study the fragmentation and fertilization of the various disciplines in this ecosystem. The lowest common denominator in the fall lecture series is to enhance and provide a deeper understanding of international law through international lawyers. The Society for its members is a place to congregate, to discuss, and have thought-provoking discussions, which will be the resultant of its engagement with speakers of eminence and distinguished capability. Our speaker today, who is the author of a book which is critically acclaimed and is entitled The Existing Legal Limits to Security Council Veto Power in the Face of Atrocity Crimes. Upon having a cursory glance in the book and also thoroughly enjoying that, and also preparing for my classes on UN and the law conducted by Professor Popowski, the main argument of the book is that there is a both legal and moral obligation on the permanent members of the United Nations Security Council to refrain from the use of force and of veto in the face of atrocity crimes. Laced through the argument is the implicit imposition that failure to address the question of veto might have an effect of legitimizing humanitarian intervention, which the book accepts to be fundamentally flawed. Yet, the book also covers an implied false multiple choice. This is the outlining the veto in relation to atrocity crimes, which is perhaps the main thesis of the book. The book also covers the unilateral humanitarian intervention. The international community having its hands tied behind their back and watching helplessly atrocity crimes such as those in Darfur, Syria, and most recently, Afghanistan. The book also postulates that the responsibility to protect doctrine, seen correctly as a replacement for humanitarian intervention, must have some legal context. In the context of atrocity crimes, this legal content implies the responsibility of the permanent members not to veto resolutions on atrocity crimes. As seen specifically in Chapter 58, it is contested that the proposition that the responsibility to protect its legal doctrines is a legal concept. It is fortunately not necessary to do this here because the book puts forward the proposition that the proposition in itself has three concrete legal arguments. Those being that the exercise of the veto in circumstances would be inconsistent with jus cogens norms. The exercise of the veto in circumstances would be contrary to proposed principles of the United Nations. And thirdly, that the exercise of the veto in circumstances would be a breach of specific treaty obligations. I remain grateful to Professor D. Neutrality, who provides an excellent summary of the book and is involved in a symposium of this very excellent book. Before I formally introduce our speaker, let me also share an interesting review which I came across by Richard Gladstone, who's the former founding prosecutor of the ICTY and the ICTR, which is the Tribunal for Rwanda and also Yugoslavia. He said, and I quote, "In this book, Professor Jennifer Trahan presents a new major thesis that when permanent members of the Security Council threaten or use their veto power to block measures aimed at preventing or punishing genocide, war crimes, or crimes against humanity, they must be acting contrary to international law." She persuasively argues that the use or threat of the veto in such situations can contravene fundamental norms of international law, key international conventions, and the purpose and principles of the United Nations Charter, and suggest ways to challenge the current state of affairs. Let me also acknowledge the importance of this day prior, the eve of the 9/11 attacks, and as an extremely important day, not only for the United States of America, but humanity at large. Our speaker today is Professor Jennifer Trahan, who is a clinical professor at NYU's Center for Global Affairs, where she directs the concentration in international law and human rights and teaches a variety of courses on international law. She's a prolific scholar, as suggested. She has also authored scores of law review articles and book chapters on the International Criminal Tribunal's crime of aggression. Her book, which she'll be talking about today, Existing Legal Limits to Security Council Veto Power in the Face of Atrocity Crimes, was published in the summer by Cambridge University Press. She holds various positions in the American branch of the International Law Association. She's also recently served as an amicus curiae to the International Criminal Court on the appeal of situation regarding Afghanistan and serves on the Council of Advisors in the application of the Rome Statute to cyberwarfare. With those words, I now welcome Professor Trahan and request her to please kindly present her views. Professor, the floor is yours.
Thank you so much. Thank you for that lovely introduction. And it is a great pleasure to speak at Jindal Global Law School and from what feels like the other end of the world. Warm greetings to all your students and colleagues joining. I will discuss some of the highlights of the book, not all of the areas, but I will focus really on the veto power, starting with where does this veto power come from and how do we understand it given its origin. Then I will talk specifically about vetoes that have been used while there's ongoing atrocity crime. So the problem I'm writing about. I will then describe the current approach of the UN, which I will call voluntary veto restraint, asking the permanent members voluntarily to restrain their vetoes, which I will argue is not sufficing. And then I will go into my legal arguments that Professor Malhotra just outlined, the three legal arguments that I pose to challenge, to question, is this really how the UN is intended to be functioning? So if we go back to the early drafting of the UN Charter, or what became the UN Charter, we see many of the key negotiations conducted between the US, UK, and Soviet Union. At key ones at Yalta, later at Dumbarton Oaks. And it was the Soviet Union insisting on the veto, but at that point they were calling it the principle of unanimity. And the assumption was that if the permanent members would become the major troop contributing countries to the UN, they should have this extraordinary power. And of course, this is not exactly how it has played out. But there was debate in the negotiations prior to the finalization of the charter that the US and UK took the position, if a country were involved in the situation in question, then it shouldn't have the veto power. And the Soviet Union pushed back and said, no, it must have the veto in all situations under Chapter 7. And then that is what went into the charter. Going to San Francisco, where the negotiations were concluded at the War Memorial Opera House, many other states pushed back, again, questioning why this tremendous power. And there is this famous anecdote that the US delegate said, you can tear up your charter if you don't want this veto power. And of course, leading in, it was thought there would be 4 permanent members, with France a later addition. But I would argue even in 1945, it was not a completely unlimited veto power, because we see it framed in the charter as bound by the UN's purposes and principles. And I'll go into those later. So I would argue it was never fully unlimited. And even in 1945, there were nascent notions of jus cogens. And I will argue that these also inform our understanding of the veto power. Now, all those listening will know there was extensive veto use during the Cold War by both sides related to their spheres of influence. And we actually, interestingly, have pleas for veto restraint. We have the first one by the General Assembly in 1946. So we have a series of early resolutions from the General Assembly asking the permanent members to restrain their veto use, because there's genuine fear that the new UN will lapse into the dysfunctionality of the League of Nations. This culminates in the Uniting for Peace resolution, which is one way to bring debate from the Security Council to the General Assembly, which the US was then seeking to do to get authorization for the Korean War. So we do have that mechanism, but it's only been used infrequently. And of course, the General Assembly does not have all of the powers of the Security Council. So I will argue the General Assembly cannot always do what the Council could. It maybe can take some initiatives. We see it recently having created the IIIM for Syria, evidence collection, but that was not what the Security Council was proposing. So it sometimes takes lesser measures. So I will argue the veto really is problematic. So coming out of the Cold War in the 1990s, we went through a period of optimism that the UN Security Council could function more. It's in this time period that we have the Yugoslav and Rwanda tribunals created. But of course, I would say that period of optimism was maybe short-lived. We're not back in the Cold War, but some of the dynamics are still there. So what are the vetoes that I'm discussing? I would point out those used related to South Africa. So we have vetoes by the US, UK, and France that Richard Goldstone will agree, delayed the dismantlement of apartheid. In the context of the Rwanda genocide, the veto operates differently. It is more the veto threat. The US, UK, and France, again, they do not want the word genocide used during 1994 by the Security Council, feeling that would create the responsibility to do something. there is the obligation to prevent genocide in its Article 1. And of course, there was also an underlying unwillingness to commit troops. So it's a somewhat different dynamic. When we go to the situations of Darfur, Sri Lanka, and Myanmar, I would argue we see relative passivity out of the Security Council in all those situations. And here it's mainly the veto threat. So I have a chapter in my book, chapter 5.2, looking at veto threats related to Darfur. And I trace that all the while that we have accelerating crimes against humanity, war crimes, and genocide occurring, and a death toll of 450,000, what you have is the Chinese veto threat watering down the sanctions regime and watering down the mandate of the peacekeepers, delaying the deployment and insisting on a hybrid consensual deployment that arrives years too late, while the majority of the crimes have all been committed. In Myanmar, we have one actual veto, so that's in 2007. There would have been condemnation of the crimes, and this gets vetoed. And the problem with such a veto is not simply that resolution, but it conveys, I would argue, a virtual green light to perpetrators on the ground that they have a protector on the council who will veto measures against them. And then, of course, we go into the horrific atrocities in Myanmar, and really nothing out of the Security Council, because it's very clear there would be a veto by China if the council tried. So if the council can't even get out condemnation of crimes, it certainly cannot ratchet up to other measures. In the conflict in Syria, we've seen perhaps the most dispiriting set of vetoes, 16 vetoes. I should add also, before I forget, I do include US vetoes related to Syria. My book doesn't focus on those, but I do mean all vetoes in the face of genocide, war crimes, crimes against humanity. I do not exclude any permanent member. But in Syria, we have certainly seen the most dispiriting set of vetoes, with 16 vetoes, some double vetoes, Russia, and sometimes joined by China. And these can be grouped in ones that blocked condemnation of crimes, one that blocked referral to the International Criminal Court, a series of vetoes blocking measures that would try to alleviate some of the chemical weapons use, including imposing a certain joint investigative mechanism that would have attributed responsibility to the side using the chemical weapons that gets vetoed, and a series of vetoes that block humanitarian relief. And I think we have to ask ourselves, is this the charter as it was designed to function, to block chemical weapons attacks, to block humanitarian relief? Can this be permissible to block measures in the face of genocide? Can this be permissible under international law? And I will just note that on the chemical weapons veto, when they first start these weapons inspections, we actually have a decrease in fatalities, decrease in chemical weapons attacks. And when we have 3 vetoes, it's a triple veto of this investigative mechanism, we have a rise in fatalities. So on this one, there's a pretty clear linkage between the veto cast and fatalities on the ground. So put together, the way the veto is being used, I would argue, costs lives. So what has the UN been doing about this? We first see notions of sovereignty as responsibility being articulated in 1996 by Francis Deng. And then we go into, of course, importantly, the responsibility to protect the Canadian Commission, International Commission on Intervention in State Sovereignty. And of course, RTP's agenda can be entirely blocked by the veto. And embedded in the ICISS report of 2001, they already then call for veto restraint. We see this echoed in the work of the S5 group of states, small 5, Costa Rica, Jordan, Singapore, Switzerland, and Liechtenstein, calling for veto restraint, tabling a GA resolution in 2006. That one is later withdrawn and reproposed in 2012, but when it is declared they need a 2/3 GA vote and pressure has been put on certain countries in terms of their voting, they withdraw it because they do not believe it can obtain the 2/3 required vote. But it becomes the genesis for the two important veto restraint measures we have today: the ACT Code of Conduct, ACT being accountability, consistency, and transparency, and the French-Mexican Initiative. The French-Mexican Initiative is, of course, very significant because a permanent member is leading it. So we even have a permanent member saying that veto should be restrained in the face of genocide, war crimes, and crimes against humanity. And at the latest count, I believe it was 105 states had joined the French-Mexican Initiative. The ACT Code of Conduct is formulated somewhat differently. It calls more generally for Security Council transparency, and then it calls for a positive pledge by all states to vote, not to vote against a credible draft resolution before the Security Council on timely and decisive action to end genocide, war crimes, and crimes against humanity. And I believe it has 122 states parties. There were other veto restraint measures. We have one by a group of known as the elders that had been created by Kofi Annan and Nelson Mandela. These are elder leaders of the UN system saying the veto should not be used in the face of such atrocity crimes. Hans Corell, who was Undersecretary General for the UN and the head of the UN legal office for many years, has his own proposal for veto restraint, although he now endorses my proposal as well. And the US even had a genocide prevention task force, bipartisanly chaired by US Secretary of State Madeleine Albright and US Senator, a Republican Senator, William Cohen, calling for veto restraint. Did not result in the US endorsing this as formal policy. But all put together, we've had many calls for veto restraint. I analyzed their differences in chapter 3 of my book. They differ slightly on which crimes are covered, whether the threat of the veto should also be covered, whether the threat of the crimes, when it is threatened that the crimes are only threatened to be occurring, whether that should be covered, whether an outside body should be a trigger mechanism to declare, yes, the crimes are occurring, we're at serious risk of occurring, whether there should be an explanation by a permanent member casting its veto, and whether some have argued there should be a carve out in states' vital national interests. I would argue against that one for a variety of reasons, and whether there should be a carve out. I read the ACT Code of Conduct formulation said there should be no veto of a credible draft resolution, and that opens a Pandora's box of what is a credible resolution. Also a formulation I would not endorse, or I think there are loopholes in these two words. Put together, despite all the differences, we can say we've had 20 years of calls for veto restraint, actually more than 20 because we have them already in the late 1940s. And then we have had 20 more years of calls for veto restraint in the face of genocide, war crimes, crimes against humanity. And actually 2 permanent members endorse these because in terms of the ACT Code of Conduct, we have both France and the UK joining the Code of Conduct. So that is very significant. But on our negative side, these are soft law documents. So a code of conduct is not purporting to state hard law legal obligations. And the French-Mexican Initiative is coined a policy declaration. So again, not purporting to state hard law. And I think more significantly, 3 of the permanent members do not endorse these initiatives. So when the US, Russia, and China do not endorse voluntary veto restraint, in the end of the day, we don't have veto restraint. So I then go to my legal arguments and saying, well, let's look at this from the position of hard law legal obligations. And I don't actually say all aspects of R2P are hard law, but that there are hard law legal obligations underlying R2P. And I also look at these in terms of veto use. So as Professor Malhotra outlined, I basically look at the veto in 3 contexts. How does it measure up to use Kogan's? What about considering the requirements of the UN Charter itself? And then I look at certain treaty obligations. And these arguments can be found in chapter 4 of my book. And I phrase these as independent arguments. So if you were to take this to a court, I think each one would be either entirely or pretty much could be phrased as freestanding. You wouldn't need to prevail on all three to press this case. I start by the simple theoretical construct. Of course, the veto is found within the UN Charter. It's found in Article 27.3. So this is the context. We don't see the veto, but it says, no vote by negative vote by a permanent member. It is there, but the Charter sits in a context of a system of international law. And we talk about jus cogens as the apex of the system. Certainly, the rest of the Charter is also relevant to Article 27.3. And then we also have treaties such as Genocide Convention obligations and Geneva Convention obligations. And hopefully someday we will also have, someday soon, a Crimes Against Humanity treaty as well. And then we could look to that treaty. Currently, it's obviously in the finalization and drafting. I'm going to give maybe the 5-minute version of my legal arguments. They take over 120 pages in my book, so the full articulation can be found in my book. So the first argument focuses on jus cogens. So we say that genocide is a peremptory norm, crimes against humanity, war crimes, at this very highest level of international law, or at least fundamental provisions of international humanitarian law, which would certainly at least cover certain of our war crimes, are at this very highest level. So I have kind of 3 ways one could articulate what I see as a real inconsistency. If we say these crimes receive the very highest level of protection in that no state can opt out of respect, and no state may commit these crimes, and all states must respect that they are at this highest level, then how can the veto be used so freely to thwart measures to prevent them? So I would argue at minimum, it is an inconsistency between the protection accorded jus cogens and the UN, how the veto is being utilized. More aggressively formulated, in some situations, you could really say the permanent member is facilitating the ongoing commission because they are blocking measures to stop atrocity crimes. And one could also see this formulated in the ILC Articles on the Responsibility of States, Article 41.1, which recognizes a duty of states to cooperate to bring to an end through lawful means any serious breach of an obligation arising under a peremptory norm of general international law. So if they're blocking measures, they're certainly not cooperating to bring to an end serious breaches of peremptory norms. Moving very quickly to the second argument, when we look at the UN Charter, it is framed by certain purposes and principles. And these, importantly, in Articles 1 and 2 of the Charter include respecting international law, respecting human rights, the obligation of good faith, and the obligation to cooperate in matters, international problems of a humanitarian character. I would argue some of our veto use is out of line with all of these obligations. I would also argue that in Article 24.2, we see the Security Council as a whole under the Charter is instructed, it is bound by the UN's purposes and principles. Now, if the Council as a whole is bound, individual permanent states must be bound because they cannot have a power that is greater than the power given to the Council. They are a part of the Council. But these purposes and principles are also binding on the permanent members because under the Charter system, these purposes and principles are binding on states. And in the end of the day, the permanent members are states. So they are quite clearly bound. I go into how in the book how I see the vetoes as not living up to these requirements in more detail. My third series of arguments focuses on treaty obligations of the permanent members. The permanent members are all parties to the 1948 Genocide Convention. They're all parties to the 1949 Geneva Conventions, and certain ones are parties to the additional protocols. So under the Genocide Convention, Article 1, we have an obligation to prevent genocide. In the Bosnia-Serbia case of the ICJ, we see this is triggered not only when genocide is occurring, but already when there is a serious risk of genocide. The court articulates this is a due diligence obligation based on a state's position of influence. Well, based on that, I would argue the permanent members have particularly strong positions of influence, often due to their bilateral relations with the country in question, but also by virtue of being permanent members. The ICJ also makes clear in the Bosnia-Serbia case, this is not solely an obligation to prevent genocide in a state's territory, but is an extraterritorial obligation, actually to prevent genocide in other states. And of course, that case was adjudicating the responsibility of Serbia vis-a-vis genocide occurring in Srebrenica in Bosnia at the time of the genocide 1995. Bosnia, the FRY and Bosnia are separate states, and the court makes this very clear. The common Article 1 of the 1949 Geneva Conventions, also found in additional protocols 1 and 3, provides a similar due diligence regime. And we have it articulated in both the Wall and Nicaragua cases of the ICJ, that this also imposes obligations to try to ensure respect for the Geneva Conventions, even vis-a-vis war crimes and IHL violations in another state's territory. So common Article 1 operates similarly to Article 1 of the Genocide Convention. It is also this due diligence obligation we see in the writings of the ICRC, International Committee for the Red Cross. In my book, I look at what is required of due diligence. And maybe it is difficult. I know there are scholars who write entire books on the concept of due diligence. It's precisely to say what you have to do to exercise due diligence as a state. Well, I would argue that having a veto to stop measures to prevent the crimes is the antithesis of due diligence. So I don't have to try to define due diligence, but when you're blocking chemical weapons inspection, that's the antithesis of due diligence. So this was a short version of my arguments. As mentioned, crimes against humanity don't yet have their own treaty, but I think we can derive similar obligations to prevent them through customary international law, and we do need the conclusion of this treaty. At the end of my book, I call for states to undertake 3 measures, that they should first make these legal arguments, and some states have already been making these arguments, and I call for additional states to do so, that the charter matters, that international law matters when we look at these vetoes. And some states have already put this position on record, not that the veto should be reined in as a voluntary matter, but we need to look at it in terms of its legality. So states could make these statements. We already have a number of high-level supporting individuals endorsing my arguments, including Richard Goldstone, who was obviously prosecutor of the Yugoslav and Rwanda tribunals. The second prosecutor, Luis Arbor, has also written on the illegality of the veto in the face of genocide. Former Undersecretary General and Ambassador Hans Corell, former High Commissioner for Human Rights Navi Pillay, former High Commissioner for Human Rights Zaid Rad Al Hussein, and a number of very high-level prominent individuals as well, including Lloyd Axworthy, former Minister of Foreign Affairs of Canada, etc., have joined in endorsing these arguments. And states need to take this on. States could also entertain issuing a General Assembly resolution articulating some of these legal responsibilities. States could also consider asking a question to the ICJ on this issue. And a question could be formulated such as, is all veto use while there is ongoing or the serious risk of genocide, crimes against humanity, or war crimes consistent with international law? Put these questions to the International Court of Justice. If you read my book, most of my arguments are made out of using ICJ case law. So it is the case law from the courts, such as in the Bosnia-Serbia decision. We'll be looking for the Gambia-Myanmar case. The case law, initial case law is very, seems going in a positive direction. We'll look for rulings in that case. These can help inform because we're actually not stuck in our 1945 reading of the UN Charter, but we can look at our understanding of jus cogens today, our understanding of the Charter provisions as we read them today, our understanding of treaty obligations, the Genocide Convention, Geneva Conventions, and obligations that we have related to crimes against humanity as we read them today have to be read against this, what is the permanent members seem to see as a completely unquestioning power. And I argue even in 1945, it was not unlimited, but when seen in the context of the remainder of these obligations of our international legal system, certainly should not be unlimited today. And this challenge should be brought. It's been far too long. If we want an effective UN, as we just celebrated the 75th anniversary of the UN system, and we're looking at making it an effective institution, having this kind of logjam of the Security Council, particularly in the face of atrocity crimes, in some of our most difficult situations, is really rendering hollow the promise of never again when it's simply blocked by the veto power. And countries should not allow this to go unchallenged. And legal scholars, I hope, will also take up these arguments and make use of them. So I will end my remarks here and take any questions or discussion. Thank you.
Thank you so much, Professor. That was a riveting talk and perhaps quite thought-provoking as well. I'm also appreciative of you for announcing me as a professor. I'm still studying, but thank you so much nonetheless. I appreciate your very kind gesture. And I perhaps think that the real crime against humanity is to have you for such limited time and to not hear you and the entire book as a lengthier discussion. I do have questions in mind as well, but I'd request Professor Tripathi to share her thoughts, and then we open it up to others also to share their views and perspectives and questions. Professor Tripathi.
Thank you so much, Professor Trahan. Thank you so much, Ankit. To delve into such, I would say, a convoluted scholarship, which not only is limited to theory, but also has to take due consideration of the real politics that surrounds the inquiry that Professor Trahan has delved into, is not an easy task. What I would very honestly, as a young scholar of international law, would like to bring forth is that when I was going through a lot of reviews and through a preliminary reading of a book, what I observed is that there is a repeated question or a question on loop that has come forth through time and again to increase the accountability of the Security Council. And sadly or ironically, as one would say, we've had enough examples in the past, in the recent past, such as Syria, and even if we go a little further through Rwanda, to tell us that timely action, power without timely action is as ineffective as a judicial system that does not respond to the needs of their subjects, or a timely decision in a judicial dispute. So to look at the scholarship, firstly, there is a general observation that the Security Council cannot be touched upon, or there are no limits. But this very precise legal inquiry that Professor Trahan has done to find justifications in form of genocide, crimes against humanity, and war crimes, and also to bring it in line with the basic, I would say, obligations that have been highlighted under the UN Charter, under Article 24, Clause 2, that the Council has to act in accordance with the purposes and principles of the United Nations. And these principles include principles of justice and international law, promoting and encouraging respect for human rights and good faith. So these three limitations that Professor Trahan has duly justified in her exploration of revisiting the power of veto under the Security Council, I think, despite the limitations that she has so humbly presented before us, very obviously talks about the need for the Security Council to introspect. While I would like to very obviously talk about this observation that a number of scholars also made, to expect an amendment in the power of the Security Council. I don't know if we will be able to achieve that success, but definitely a complementarity with the other members of with the General Assembly taking charge. And in fact, I would like to refer to Dr. Popovsky's scholarship, in fact, that the expansion of the Security Council, especially with in different areas such as climate change and human rights and the like, maybe the focus and the responsibility and the expectations of the Security Council as it exists can be bifurcated, can be delegated with the keen issues that are arising before us. And especially with climate change, especially with the pandemic, issues of security, issues of nationalism that are coming forth before us. I don't think that the Permanent Five can take or further their, I would say, political interests as openly as possible, because France and UK have acceded to have signed, in fact, the ACT. So to see the other three members coming on board would be a gesture and a sign of hope. So I would, as a young scholar, would definitely thank Professor Trahan to give us a lot of insight into such a difficult question. So I really laud you, Professor, for taking such a tricky academic and such a tricky question and doing due justice to it. Thank you so much. Thank you, Ankit.
Thank you for those kind words and remarks. That was terrific.
Thank you, Professor. Well, I would like to test the waters slightly. I would like to perhaps further what Professor Popovsky writes. He's shared a model, and the model essentially is to, in some sense, do away with the status quo of the Security Council due to the veto powers. He propagates an idea which is essentially based on feasibility, importance, and urgence. He talks about the creation of 3 separate councils, and membership to these councils will be based upon capability and importance. These are essentially the Peace Building Council, the Climate Security Council, and the Health Security Council. So I'm quite intrigued by what these models suggest and the underpinnings, the historical underpinnings to them. I'll briefly share, and I'll request Professor to share her thoughts on those. So the Peace Building Council is, in terms of feasibility, it is the easiest to create by transforming and empowering the already existing Peace Building Council, and already proposed and explain, which is already proposed and explained in the an innovation agenda for UN 75 by the Albright-Gambari Commission report and the Road to 2020. The second, which is the Climate Security Council, which is arguably the most important, as it addresses one of the most critical issues of the 21st century, and it would be effectively approaching the issue and its implications resulting from intensive weather-related disasters. The third is the Health Security Council, which is most urgently needed, especially considering how many lives have been lost to COVID-19. and due to the ignorance, lack of coordination, and deep gaps in global health governance. So these are three models and three proposals to a multiple security councils, given how the current model, at least in some sense, has failed. Professor, I seek your analysis on this.
Well, I think it's a really intriguing proposal in that, as we all see from the depressing news that surrounds us almost every day, I mean, there's so many challenges facing the international community right now. And the notion that, one Security Council isn't fit to task is an intriguing one. I think, I have the idea of three separate councils focused on peace, climate, and health is a good one if the votes, if there is the political support. So that's the whole question. So if you go to Article 108 of the UN Charter, for an amendment of the UN Charter, you need 2/3 of the members, so 2/3 of 193 states to agree to it. And then you need all the permanent members. So it would have to be structured in a way that you get 2/3 of all states and all permanent members to agree to it. So it seems a very good idea, but that's a formidable hurdle. What I try to do is, given the current structure, and I don't, it was mentioned amendments to the charter, and I should just say for the students in the audience, amendments of the charter are, as mentioned, very hard. I just read the amendment rule. It's a very hard thing to do. So I kind of take it, the veto is there. The veto is not going anywhere because an amendment to the charter would require all permanent members to agree. So I don't think we're going to have any formal amendments to the charter. And that is why I challenge it from using other aspects of the system of international law to work, given the charter structure, the Security Council structure we have. I know Direk Ladi in his post critiqued me, you're propping up an illegitimate institution. And I'm kind of like, well, it is the institution we have. So if you don't throw out the entire UN system, which I don't really conceive of that being a good idea, and I don't quite conceive how that would peacefully work. Yes, I am trying to make the institution we have function better. Dividing up its work might be a way of making it function better. If this can possibly be done without a charter amendment, which might be an intriguing question. Do you have to do that through a charter amendment? Just because the votes are hard to get. So we have to work in the realm of what is politically possible. So I'm challenging the veto from other aspects. So not doing a charter amendment.
Well, to that question response, Professor perhaps would argue, and I think envisioned this remark as well when he was writing this. And in the paper he which I'll share in the chat for all others to read as well. What he says is that the establishment of the proposed councils is entirely possible within the General Assembly's authority to subsidiary organs under Article 22 of the UN Charter without amendment. Similarly, the General Assembly can adopt all budgetary decisions needed to support the new council's work. So in some sense, you're completely overriding the current Security Council, and even for budgetary purposes. Professor also talks about Japan as being one of the forefront leaders in this project, and perhaps that would also circumvent their desire to become a part of the current Security Council. So in some sense, you kill two birds with one stone, as in their desire to become a part and in turn be a leader in themselves. So I just thought I should highlight that. There's one question which I would like to read out. It's by Rudra, who's a board member of the society, and she asks, could you speak more on your position on humanitarian intervention? While intervention that is backed by the UN sanction would indeed be ideal in situations where the UNSC is paralyzed by the veto, would you say that unilateral intervention is preferable to non-action while atrocity crimes are still occurring? So in a sense, perhaps let me add to that, you could also, at least I would like to know more about this, the humanitarian intervention vis-a-vis R2P, which is perhaps a more nuanced version of this based on the agenda of peace, which was groundbreaking in terms of research and setting the agenda essentially for peace.
Yeah, thank you for that question. So I do have a chapter on humanitarian intervention and R2P in my book. Chapter 2, I didn't talk about in my main remarks, which focused on the veto, the more directly on the veto arguments. So I guess in my own personal writing, I leave a very narrow potential opening for humanitarian intervention, which I know is not the majority reading. I recognize this. I recognize that most states say that R2P has replaced humanitarian intervention. And simply having been on the ground in Rwanda and visiting mass graves, having been to Srebrenica, I think 6 or 7 times, I still have an opening that if a country could have blocked the Rwanda genocide by seizing the machetes initially, and they had no authorization, I would have said that was the right thing to do. And they could have. They were learning of mass machete shipments into the country early on. They were having these warning signs, and their estimates, it could easily have been blocked. So recognizing the difficulties of our current system, I do leave a narrow opening for humanitarian intervention. Particularly, I distinguish and argue it would not be the ICC crime of aggression, International Criminal Court. I should mention that in writing about the 3 atrocity crimes, I do not mean to minimize the significance of the 4th ICC crime, the crime of aggression. At one point, the US argued the US can't join the ICC. There can't be this crime of aggression. It criminalizes humanitarian intervention. And I think it doesn't, narrowly construed, because I think humanitarian intervention is kind of in a gray area of legality. It's sometimes morally compelling, if not strictly legal. So we kind of come out with something like that. And I argue because the crime of aggression is only criminalized as a manifest charter violation, it wouldn't criminalize humanitarian intervention. So I leave a narrow opening for humanitarian intervention. But if we're going to have it, I think we need much more scholarship, much more agreement on what are the criteria for it. The UK has articulated criteria. Other countries really don't want to go down this framework. They endorse R2P, but R2P is being completely blocked by the veto. So R2P says, yes, the international community has a responsibility, but it only authorizes Pillar 3 use of force when there is a Security Council resolution authorizing it. And that is where we come into the veto. So we don't even need to get into the sticky question of humanitarian intervention if we fix how the veto is being used. Then we don't have to try to get around the charter system in morally compelling cases, because the charter could actually function correctly. So if we fix the veto, then we don't have to get into all this gray area analysis. But that's kind of where we are. So I give a very qualified endorsement to the UK position, that there still is a little bit of potentially humanitarian intervention left post the development of R2P, which I believe is also the French and US theory for the chemical weapon strikes into Syria in response to chemical weapons use. They didn't articulate a legal theory, but the UK has, and the UK and France and the US joined in the same military strikes. So some countries seem to leave a tiny opening. I believe that Denmark does as well. I think we have to recognize the rest of the community is deeply wary of this concept. So I think Global South states, many African states see this R2P and the legacy of colonialism. So they don't see these, white knight, first world countries coming in, but they're deeply suspicious, and we have to recognize. And I think if humanitarian intervention is not well defined, what is bona fide humanitarian intervention? What are the criteria? And Harold Coe actually in his writing has called, he says these need to be defined. I would agree with it, but we don't have most of the community on that approach. So I go back to, well, if we actually fix the veto issue by bringing some challenges, we wouldn't have this blockage that we currently are seeing, which then I have to make these convoluted arguments in a slight defense sometimes of humanitarian intervention, and knowing this is not the majority approach of states. Thank you for that question.
I was just scribbling a note since you mentioned Co, because Co writes quite profoundly on why international law is abided by, and then the thesis of that article is essentially because there remains a stronghold of its binding nature, and I was also seeing one of his discussions with Kande on the use of force and private island sources which are used specifically for the purposes of interrogation. Right, but anyway, I'm also quite fortunate that you've mentioned the global south. I'm going to play the devil's advocate over here. I don't agree with this view, but what essentially then plays out is this perception of a white man's burden, the perception of a neo-colonialist approach towards this. And I talk in reference of Diego Garcia and the advisory opinion in that respect. The Chagosians understand this perspective of the importance of the military base, but also seek self-determination. And I think this is the main problem when it comes to such issues. The global south, even when Kosovo was attacked by Western scholars and Western perspective, was hailed as a success. But NAM, the non-aligned movement, considered it as a breach of state sovereignty. So these opposing views remain, and I think the lacuna there, the cleavage deepens even further because of the fact that there remains a lack of common understanding and issues. So, but I still feel quite convinced that, at least in the aspect, or at least in the scenario of Diego Garcia, given its importance and also given how aggressively China is moving forward, a military base in some sense is perhaps a necessary evil. Where would you align yourself in this situation?
I agree with you that there are gulfs between some of our legal analysis is viewed, and international law, particularly the formation of customary international law, has been somewhat dominated by certain countries. And all countries need to be part of this. And I agree, very different views of the Kosovo intervention. I would simply say, I don't think we can, answer that one. So maybe I'm slightly ducking your question, but I would say, I bet that global South scholars wouldn't support the veto in the face of atrocity crimes. I bet we could find common ground when we're talking preventing genocide, war crimes, crimes against humanity. I bet there's no division between global North and global South. And I forgot importantly to say, Adama Dieng endorses my arguments as well. So I'm definitely working with some of the most prominent scholars from the African continent. When my arguments have been endorsed by Richard Goldstone, Navi Pillay, Adama Dieng, just to name a few. And I'm also working with a loose coalition of NGOs, and they include some coalitions from Africa, the Association des Victimes de la RCA, and Central African National Coalition for the ICC. So from Central Africa, as well as some of the global NGOs who support. So I think we would have alignment when it comes down to preventing atrocity crimes. On the use of, well, I guess Kosovo is arguably a situation of the prevention of atrocity crimes. So, but if we never needed to have reached that if we'd had the Security Council working. So the reason that NATO kind of goes outside the charter system, technically, although I would defend NATO's operation in Kosovo as preventing potentially another genocide, following on the heels of Srebrenica and mass atrocities in the former Yugoslavia, NATO actually acts promptly to prevent what seems to be mass ethnic cleansing starting in Kosovo. But they do it somewhat they're through a regional organization, which is certainly preferable to unilateral action. And it's often defended as humanitarian intervention. Sorry, I've lost my train of thought on that one. Oh yes, but we need, why they didn't go to the Security Council for the authorization is they anticipate it would have had a Russian veto, because Russia historically is aligned with Serbia. So if there had been a proposal for a forced authorization, Russia would have vetoed. Now, if you don't use your veto in the face of atrocity crimes, which they were certainly at risk, then we don't get to the situation of having to do these convoluted justifications for NATO's intervention, because you could actually have a UN authorized operation to try to prevent the crimes. And I think that is the preferable way to use the UN system and to have the UN system functioning instead of having to try to, how can we rationalize going outside? I again do give a qualified defense to NATO's intervention in Kosovo, which I see on the heels of mass atrocities in the former Yugoslavia. You know, are they going to have it happen yet again? But it's hard to reconcile with the charter framework. I do have certain arguments for doing so, and I explore these in the book. And even Richard Goldstone, I think, he led the Kosovo Commission as well. And they come out with some formulation such as something like it's morally compelling, if not strictly legal. We're all kind of come out with this nuanced response to Kosovo. But if the charter worked as designed, we don't get into these complicated legal arguments, because I think we could have more agreement within the council.
But I also add over here Sir Christopher Greenwood, who provides a compelling perspective on humanitarian intervention in the Finnish International Law Journal in 2002. With those words, Professor, let me thank you for this very riveting and thought-provoking discussion. We're grateful and we're highly obliged to host you once again. And so shall we be more than glad to host you in December in our bigger panel discussion on the United Nations and its reform. I hand the floor back to you and request you to please share final thoughts, after which we will close. Professor.
Yeah, great, thank you. And I just see one question. What about gender neutrality and biases? So again, I maybe, and the veto, I maybe am not fully answering the question posted in the chat function, but I will say a lot of atrocity crimes are, you know, crimes against women. And when we have the veto, you know, it's actually, you know, both genders and all, we don't have to be in a binary gender spectrum. Everyone is suffering. So crimes against women, you know, we've seen horrific mass atrocity crimes in the context of Rwanda genocide, mass use of rape in the context of the wars in the former Yugoslavia. So this veto issue is a gender issue, because the atrocity crimes are tremendously, you know, impacting on women, but also male victims of rape, and, you know, and all others who suffer from this. So it is, I don't particularly analyze the veto from the gender lens, but I would say it is impacting. We do have tremendous impact on women. So my concluding remarks is, I hope the young scholars listening to this talk will look at these arguments and will consider writing on these arguments and pushing countries, if you're in such a position, to take up these arguments and look seriously at them, and to see which ways you can improve the international legal system, because it's very easy to be critical of the system. And of course, what we need is to make it function better. And I would argue function as designed. Did the framers ever mean the veto would block the prevention of atrocities? I don't think so. We don't have discussion, because the charter discussions were, you know, before the Nuremberg Tribunal. So they were before the Tokyo Tribunal, before a field of international justice. So we can't have the direct thoughts of the drafters. You know, did they mean you can use the veto to block measures to stop atrocities? In other words, use it to allow atrocities to continue. Is that what they meant in designing the charter system? It seems really counterintuitive. So I think it's important to give critical thought to these arguments, to try to advance them, and to try to push NGOs and states into action to take up these kinds of arguments. So I'll end it there. So thank you very much. and I look forward to our broader discussion in December.
Thank you so much, Professor. And let me just also add to that period was also coinciding with European efforts, and specifically the European Convention on Human Rights. I mentioned this because I'm actually doing a presentation on that and the efforts made by Winston Churchill, nonetheless, and how he became the founding father of the Council of Europe, which advocated for groundbreaking and quite essentially earth-shattering legislative purposes and intent, while also enjoying life at Chartwell Manor. With those words, I thank everyone else as well who've joined us and become part of our society and our discussions. We are thankful, and we are also highly obliged to welcome you in our discussions. We will return next week, and we will next week travel to the deserts of Middle East and North Africa and discuss international organizations' efforts over there with Siraj Khan of the Max Planck Institute. Thank you, everyone, and wish you a very relaxing weekend. Thank you, Professor.
Thank you. Goodbye, everyone.